بسم الله والحمد لله والصلاة والسلام على رسول الله وعلى آله وصحبه ومن والاه ثم أما بعد. To proceed. So today inshallah we will be finishing the fourth qaida, the fourth legal maxim. That's qaida kulliya kubra. That's major legal maxim. And this is al-mashaqqa tajlib al-taysir, or hardship begets facility. And what we've covered so far, I guess we did like maybe 6 or 7 sessions on this qaida. What we've covered so far is the meaning of the qaida, the guidelines, and the benefits. And then we started to go over the subsidiary maxims, and we've covered 8 of them. Certainly, we covered the ones about darura, because darurat tubih al-mahdhurat, or necessities permit prohibitions, is the most known subsidiary maxim under al-mashaqqa tajlib al-taysir, and it deserves to be the most known. So we've covered that, and we've covered the basis of it, which is taklif mashrut bil-qudra. That's the basis of it. Taklif mashrut bil-qudra means that obligations are contingent upon capacity, and we have also covered the regulatory or the regulations of this qaida. The other qawaaid that we've covered last time are regulatory qawaaid. They regulate our understanding and application of ad-darurat tubih al-mahdhurat, or necessities permit prohibitions. Necessities permit prohibitions. So today, inshallah, we will address a different one. We will address the 9th and last subsidiary maxim, and it is pretty different from the ones before it, and extremely important. So today's session will be longer, perhaps, but I wanted to finish the discussion on al-hajat, or the needs, or al-masalih al-hajiyya. I want to finish this in one session because it just wouldn't make sense to break it up into 2 different sessions. So today we will go over ما حرم تحريم الوسائل جاز للحاجة, which means what is prohibited as a preventative means will be permitted for a need, or maybe permitted for a need. And the second part of this, and this is like 2 qaidas merged into one because they are very interrelated. The second part of this is والحاجة العامة تنزل منزلة الضرورة الخاصة, which would mean the general need may take the ruling or assume the ruling of الضرورة الخاصة, private individual necessity, public need versus individual necessity. All of us need this. I, direly need this. These are different discussions. So, Imaman, Suyuti, and Ibn Nujaym, rahimahum Allah, they had a formulation of this qaida that we find a little bit difficult without modification, to completely adopt without modification, not because they meant anything wrong, but because of the ambiguity of the formulation. The formulation of Imam Suyuti and Ibn Nujaym is al-haja تنزل منزلة الضرورة عامة كانت أو خاصة, which would translate into the need takes the ruling of necessity, whether it is public or private, general or specific. So it appears that this formulation is difficult to adopt. It appears that they may have meant that the hajat have a legal effect, just like darurat have a legal effect. And the legal effect here is what? Facilitation. So hajat bring about facilitation, just like darurat bring about facilitation. But the ambiguity in the formulation is that someone who reads this may think that haja is really treated like darura. And in this case, we would be doing away with the distinction between darura and haja, and anybody who needs anything can do whatever he wants, and there would be basically no prohibitions in the deen, or that would compromise to a great deal the integrity of the Sharia if it is misunderstood. Now, they did not mean that, of course, we think well of them, but if it is misunderstood, that's why the formulation needs to be adjusted. In our Hanbali madhab, this particular formulation has not been mentioned. This particular formulation has not been mentioned by earlier Hanbalis. So you don't find among earlier Hanbalis anyone talking about the private, that haja or a need, whether private or public, will assume the ruling of darura or necessity. In fact, Imam ibn Qudama explicitly said that al-hajat are not consequential, that al-hajat are not consequential in the sense that he said legal rulings not built upon legal rulings are not built upon hajat or hajiyat. Legal rulings are not built upon hajat or hajiyat. But he said, and that is very important because that is what we uphold as well, unless there is a supporting basis or precedent. يشهد لها أصل. يشهد لها أصل. This haja, لابد يشهد لها أصل. Some precedent or basis must testify on behalf of this haja that it is consequential. So a haja, like a need of yours, that the Sharia has never basically testified to its consequentiality in the legal rulings, is basically dismissed, is basically not considered a cause for facilitation. The Sharia has to testify. The Sharia has to say there is a precedent. This particular, haja, there is a precedent that the Sharia made accommodations for it, as we will discuss in much detail, inshallah. So based on this, based on the ambiguity of that formulation, we choose the following formulation. We choose that the formulation that we started with when we started, ما حرم تحريم الوسائل جاز للحاجة, which will mean that which is permitted as a preventative means, prohibited as a preventative means, not prohibited in and of itself, تحريم مقاصد, but تحريم وسائل as a preventative means because it leads to something bad. These types of prohibitions may be allowed for haja. And the second part of the qaida is al-haja al-amma, the public need, would assume the ruling of al-darura al-khassa, the private necessity, and not the way they said it. Al-haja amma kanat aw khassa, need, whether it's private or public, will take the ruling of necessity because that ambiguity ought to be removed. So, and in the didactic poem of Shaykh ibn Uthaymeen rahimahullah, he said, لكن ما حرم للذريعة يجوز للحاجة كالعرية. لكن ما حرم للذريعة يجوز للحاجة كالعرية. That which is prohibited as a preventative means may be permitted for a need, such as the case of araya. Araya sales, araya transactions, we've spoken about them before, when you exchange dry dates for fresh ones on the palm trees. Jurists were, so the reason why we're having this discussion, we felt like we should finish the discussion last time. We've talked about darurat tubih al-mahdurat necessities permit prohibitions. We've talked about all the regulatory maxims that will basically fine-tune and regulate the use of this قاعدة ضرورات تبيح المحظورات. And that's it. المشقة تجلب التيسير should have been done. مشقة تجلب التيسير, hardship begets facility as a قاعدة should have been done. So why are we going back to discussing the haja? Keep in mind, the distinction between haja and darura is not always that clear, is not always that straightforward. And even the jurists would disagree over whether this is haja or darura. What happened is our jurists were strict in their definition of necessity. Most of them were strict in the definition of necessity, darura. Basically, necessity for them meant that you will lose your life, you will lose a limb, you will lose a faculty. Lose your life, lose a limb, lose a faculty, lose your eyesight, lose your arm, lose your life. That's a necessity. But then afterwards, the jurists basically examining the tradition, the tradition of the earlier generations, examining the sunnah of the Prophet ﷺ, the practice of the companions radiallahu anhum, they felt that not just those necessities create facility or call for facilitation. It seems that in the sunnah of the Prophet ﷺ, much more than that brings about facilitation, and the same applies to the Sahaba Ridwanullahi alayhim. So that is why they came up with this قاعدة الحاجة تنزل منزلة الضرورة عامة كانت أو خاصة, which is needs take or assume the rulings of necessities, whether they are private or public. But again, like I said, Al-Imaman al-Suyuti and Ibn Nujaym would have not meant this in the sort of the general sense or the absolute sense of the statement that haja actually is just like darura. So to support their position that hajat take the place of darurat, they cite bay al-araya, for instance, exchange of the dry dates for fresh ones on the palm trees. And bay al-araya has about 3 major prohibitions combined in one transaction. 3 major prohibitions combined in one transaction. And the Prophet ﷺ allowed this for poor people to enjoy what? Fresh dates. They have dry dates. They can survive. They can live off the dry dates. But to enjoy fresh dates, he allowed them to make that exchange. And it's clearly a haja, not a darura. The harvesting of idkhir, for instance, when al-Abbas radiallahu anhu said to the Prophet sallallahu alaihi wasallam, please exclude al-idkhir from this prohibition, the prohibition of basically harvesting the vegetations of the haram. Please exclude the idkhir. We need it. We need it for our roofs and the different things. So he said, illa al-idkhir, illa al-idkhir, except for al-idkhir. That exclusion certainly was based on haja, not a darura. Permissibility of silk for people who have an itch. Silver fasteners, for instance, dabbat al-fidda, for if something breaks, like a mug or something breaks and you do a silver fastener, or the golden nose, prosthetics, things of that nature. All of these are hajat, not darurat, and we have seen that the Sharia did accommodate them. So to understand that the whole discussion today depends on understanding the levels of hajat and the levels of not hajat, the levels of masalih and the levels of muharramat, the levels of masalih and the levels of muharramat. So not every maslaha will make every muharram permitted. So in order for us to understand what makes what permitted, which masalih make which muharramat permitted, we have to understand very well the levels of masalih and the levels of muharramat and the types of muharramat, levels and types of muharramat. So what are the levels of al-masalih? شيخنا الشيخ محمد الزحيلي in his book القواعد الفقهية وتطبيقاتها في المذاهب الأربعة had these 5 levels that we will try to converge into 3. But to start with, it is good to basically address the 5-pronged classification because it's more textured and nuanced than the 3-pronged classification, which is more popular and easier to grasp. The 5-pronged classification, he says the first one would be necessity, that is a darura. So that is the sort of the classical darura in the definition of the fuqaha. You will perish or you will lose a limb or a faculty. The second is a need, which is haja. So you will suffer hardship and difficulty. You will suffer hardship and difficulty. You're hungry, but you're not gonna die. Like you're gonna be in distress. You're gonna be weak and in distress. Do you need to eat? Yes, you need to eat. Are you going to die if you don't eat? No, you're not going to die. You're going to be good for several days. How many days can you handle hunger, like, or starvation? Forget about water, just food. Actually weeks. So yeah, and it depends on how much fat you have, like, but you can handle it for quite some time. So, but you're weak. You're not dying, but you're weak. But so this is clearly a haja. And then there is the benefit or manfa'a. Benefit or manfa'a. These are the levels of masalih. And manfa'a, he gives an example to manfa'a. You know the difference between wheat bread and barley bread. They used to eat barley bread and not wheat bread. So what if you desire wheat bread? What if you desire rich foods? What if you have food? You have food. You have fool, for instance, every day. Fool, Egyptian thing. Okay, fava beans. You eat that every day, but you desire meat. Like, are you going to be able to survive off of the food every day? Yes, you are, but you desire meat. Is this a darura? Haja? No, it is a manfa'a. A manfa'a. If you desire lamb meat, rich foods, stuff like this. And then there is the zina, adornment. Adornment is sought for pleasure, such as craving sweets made of sugar and almonds, for instance. And these things for you here in America, 21st century, this would be nothing. But for them, sweets made of sugar and almonds is a big, big deal. So this is called the zina or adornment. And the last one is al-fudul, which is excess. To desire things that are prohibited or doubtful, such as gold and silver utensils. Some people desire that. Don't some people desire gold and silver utensils and things of that nature? Yes. So that is called fudul or excess. So this is a good classification, but in order for us to converge it into the popular 3-pronged classification, then we do what? The last 3, merge them into tahsiniyat, embellishments or enhancements. Tahsiniyat, embellishments or enhancements, the last 3. So you have a darurat or a daruriyat, you have al-hajat, the second, and the last 3, which is manfa'a, zina, and fudul. Merge them into tahsiniyat, embellishments or enhancements. But in this case, we're talking about which fudul? We were talking about non-prohibited fudul, non-prohibited excesses, because prohibited excesses would be out of the classification. Okay. So among the definitions, let's basically go back and zoom in on need, haja, because that's the topic of our discussion today. Among the definitions of need, Imam Shatibi rahimahullah said, as for needs, their meaning is that they are sought for the sake of ease and removing hardship that, if not addressed, would typically lead to distress and difficulty due to the loss of what is desired or sought. بفوت المطلوب. If they are not considered, hardship and burden fall upon the legally responsible in general, but not to the extent of widespread corruption and public interest. You know, it's not going to kill you. It's not going to make you lose a limb or a faculty, but you will be in distress. There will be hardship. We give the example, you know, of the one who's hungry. Also, you know, means of transportation. If you're gonna die without having a ride, because there are no public transportations, you know, having a ride is a necessity. If you're gonna suffer difficulty without having AC in your car, that is a need, like hardship, difficulty. If you don't have AC in your car, that is a need. If you want to buy like a fancy car, that is an embellishment, you know, tahsiniyat, enhancements. But as I said, it is not only that you should understand the levels of hajat, but you have to also understand the levels of muharramat, because as much as hajat are not created equal, muharramat also are not created equal. So prohibitions. There are some prohibitions. There is like something called tahrim maqasid and tahrim wasa'il. And the Imam ibn al-Qayyim rahimahullah talks about this in A'lam al-Muwaqqa'in and even separates between different types of riba, you know, on the basis of, is it tahrim maqasid? Are they prohibited in and of themselves because of intrinsic harm? Or are they prohibited because they lead to something else? And he says that riba nasi'a, the riba of deferment, the riba of delay, when you basically bring, like a poor person borrows money from you and you said to them, if you don't give me, you know, like they're late in payment and you say to them, if you don't pay me today, you will have to pay me more and stuff like this. He said that this is intrinsically bad, evil, therefore it is prohibited because it's intrinsically evil. That is tahrim maqasid. It's prohibited in and of itself because it's intrinsically evil. However, riba, you know, there are other types of riba, like riba al-fadl, for instance, to exchange dry dates for fresh dates. That's riba, by the way. To exchange, you know, wheat for wheat, exchanging wheat for wheat, not equal for equal, hand to hand, but with difference. Or to exchange wheat for barley, not hand to hand, things of that nature. That would be riba. He says this is not intrinsically evil. This is evil because it leads to evil, not intrinsically evil. That's called tahrim wasa'il. Tahrim, it's prohibited because it's a means to evil. Okay, so then prohibited for its very essence, like eating carrion, for instance. And then we have two other types of tahrim. So tahrim basically and let me just you know. So maybe we should defer this a little bit later when you have a better understanding. Okay, but there are two other types of tahrim. So there are things that muharram because they are intrinsically evil, and things that are muharram because of the way they were acquired. So mayta, you know, like dead, you know, mayta, or like a dead pig. Is this muharram because the way it was acquired, or it is muharram because of itself being intrinsically haram? Because itself being intrinsically haram. A dead cow, just like a dead pig, but the dead pig is more. But what about money that you acquired through haram means? Does the money itself become haram? Or it's haram for you because of acquisition based on al-kasb, acquisition, not based, it is haram based on acquisition. Therefore, this money that is haram for you may be halal for someone else if he obtains it through a halal contract. Otherwise, all of us are living in haram. So, because the money that got to you must have gone through like 700 haram transactions before it reached you. So, what matters at the end of the day is how did you acquire it? Through a legal means or contract or not? Okay. So, one will not be halal at all. So, you know, tahrim al-maqasid is stronger than tahrim al-wasa'il. Tahrim, because of inherent qualities, is stronger than tahrim because of the means or the way of acquisition. And then you have certain things that are never permitted, such as killing someone or raping, a non-consenting person. So killing and raping a non-consenting person by agreement, by consensus, will not be permitted for anything, whether it's darura or haja or anything. Not permitted, period. But there are certain other things that depend on context. You know, eating pork, drinking wine, you know, certain ribawi transactions. All of these have been permitted in certain scenarios. Gharar, you know, wearing silk, lots of things. So the question of considering need for legal alleviation is tied. Okay, so now that we know that masalih are not created equal and muharramat are not created equal, let's go back to a foundational discussion about the concept of needs and whether needs are honored in the Sharia, whether the Sharia honors the concept of needs, you know, aside from necessities, because we know the Sharia honors a necessity. Allah subhanahu wa ta'ala said, إِلَّا مَا اضْطُرِرْتُمْ إِلَيْهِ. So we know Sharia clearly, explicitly, you know, respects necessities, but needs. So the concept of needs is tied to a broader discussion. Imam Taqiyuddin ibn Taymiyyah, may Allah sanctify his soul, he said in regarding this, that this question of considering need for legal alleviation is tied to a broader issue of unrestricted public interest, you know, masalih al-mursala. And he said that it is tied to the discussion about the tahsin al-aqli, you know. So all of this, hajat, masalih, you know, istihsan al-fuqaha, juristic preference. So they're trying to do the same thing. They are coming at it from different angles. So when the Hanafis and Malikis, you know, basically argue with each other over al-istihsan or al-masalih al-mursala, actually the masalih al-mursala in the Maliki madhab are pretty much, you know, there are differences between istihsan and masalih, but it's at the end of the day, they're trying to do the same thing. And the whole concept is built on what? Masalih mursala would be unrestricted interests. Basically interests that were not invalidated or recognized by the Sharia. That is Imam al-Qarafi's definition of al-masalih al-mursala that Imam Malik acts on. And we will come to address this, and we will see that they have been recognized by the Sharia. In some sense, they have been recognized by the Sharia. Istihsan is juristic preference. That's the, you know, the Hanafis act on istihsan. They're trying to do the same thing. And all of this is tied to another discussion that's even addressed in the books of Aqidah, which is qadiyat al-tahsin al-aqli, rational discernment of good and evil. Tahsin and taqbih al-aqli, rational discernment of good and evil, rational determination of good and evil. Do we, human beings, have the capacity to determine if something is good or evil? We will come to this discussion shortly. But let us first go over al-masalih al-mursala through Hanbali spectacles. So Imam al-Tufi rahimahullah, in his Sharh Rawdat al-Nadhir, commentary on Rawdat al-Nadhir, a book that was written by Imam ibn Qudama, rahimahullah, he said that Malik and some of the Shafi'is consider the Masalih al-Mursala unrestricted interests. Unrestricted, keep in mind, they mean by unrestricted, it's not recognized by the Sharia and it is not invalidated by the Sharia. That's what they mean by unrestricted interests or Masalih al-Mursala. Okay, so he says Malik and some of the Shafi'is considered it a valid proof, and they said that we know that it falls under the objectives of the Sharia based on numerous evidences, countless evidences. And then he said that some of our fellows, and he's referring to Abu Muhammad, Imam ibn Qudama, rahimahullah, said they are not. They're not. But I do believe that Imam al-Tufi did not capture the intent of Imam ibn Qudama, because Imam Qudama was not saying that Masalih Mursala period are not valid. He's saying ما لم يشهد له أصل في الشرع. These masalih that the Sharia does not recognize, there is no basis, there is no precedent for them in the Sharia. And as I will try to explain to you, they are recognized. They are recognized. So he says that some of our fellows said they are not. We don't know that the Sharia has preserved such interest. They cite, for instance, the fact that it would be a bigger deterrent to kill the thief, not to cut their hand. Can they kill the thief to become a bigger, a greater, stronger deterrent? Wouldn't it be a greater deterrent if you killed all the thieves? It would be. And would this maslaha be considered? They say no. Therefore, masalih are not, masalih that are not recognized by the Sharia are not considered. This example shows you that they did not mean that masalih are not, what are they afraid of? أم لهم شركاء شرعوا لهم من الدين ما لم يأذن به الله? Or do they have partners who legislated for them that which Allah has given no permission for, no permission for? That is what they're afraid of. And they're afraid of something else that is basically more compelling for them to be afraid of. The abuse of power by the Sultan. The abuse of power by the Salatin. If we say to the Salatin, masalih, yes, masalih, like Sharia is completely for the masalih, then the Sultan would say, this is a maslaha, this is a maslaha, that's a maslaha, and then that's what the Salatin were doing. They were saying this is Sharia and this is siyasa. This is Sharia and this is policy or politics. Policy or politics. Policy is basically for masalih, and we are able to determine what is the maslaha for the nation. Therefore, so that will be basically a backdoor to violating the Sharia. So that is what they were afraid of. That is what they were afraid of. The examples they give you basically tell you what they were afraid of. They were not opposed to the concept of masalih being recognized. They were opposed to the abuse of the concept. The abuse of the concept. That is why you will find them mentioning examples like this and examples like what has been attributed to the Imam Malik, that he said it is permissible to kill 1/3 of the population to reform the other 2/3. قتل الثلث لاستصلاح الثلثين. So it is permissible to kill 1/3 of the population to reform the 2 other thirds. And, I have had discussions about this with, people from state security, like, and, back home and stuff like this. And that seems to be the one thing they remember from the Maliki madhab. They remember it actually quite well. But to be honest and to be fair to Imam Malik as well, this is reported by Imam al-Juwayni without any validation from true Malikis. And Imam Juwayni is a Shafi'i. So basically, the attribution to Imam Malik is at best questionable, And this statement has not been validated by the greatest and earlier Malikis. But if it is true that Imam Malik said this, then the Hanbalis are saying, well, that's what we're going to end up with if we basically recognize masalih and recognize siyasa based on masalih. That is where we're going, and that will be big, like a great sort of fitna. So then Imam al-Tufi goes back and says, he told you, some of our fellows said that the masalih are not considered. And then he will go back and say, I used some of our fellows and did not use all of them because he says that when explaining rulings, they often rely on interest-based considerations, munasabat maslahiyya, interest-based considerations, all the time. Hanbalis all the time. Read any Hanbali book. They always rely on munasabat maslahiyya, basically interest-based considerations in their legal rulings. So how come you're saying, like, and sometimes you find this, gulf between the usul and the furu'a. And that happens in every madhab, don't be like too sectarian about it. It happens in every madhab. You have sometimes a gulf between the discussions in usul and the discussions in furu'a. And what you have to do is to basically take both in consideration. So Imam al-Tufi said they rely on masalih all the time in their discussions, in their furu'a, and their explaining of rulings. And he goes even further to say sometimes they rely on flimsy considerations of interest, not just strong considerations of interest, flimsy considerations of interest. And then he said al-Qarafi, Imam al-Qarafi, the Imam al-Qarafi is Maliki. This is a Hanbali scholar, but he is referring to, because al-Malikiyya are the ones who are very well known for consideration of masalih mursala. Okay, so he quotes now Imam al-Qarafi, and he says that Imam al-Qarafi said that there are 3 different types of interests. Interests that have been recognized by the Sharia, that is qiyas. So, intoxication is recognized by the Sharia as a cause for prohibition. So when you apply this to cocaine, that's it. It's recognized. The effective cause, the illah, is recognized for the Sharia as a manat lil-hukm, as a cause for the hukm, the ruling to be based on it. That's clear. And then he said there are interests that are rejected, such as forbidding cultivation of grapes to basically deny people the capacity to make wine. So if wine is this evil and this bad, what do we need grapes for? Like really, what do you need grapes for? You could eat other fruits. But so then, was this interest considered recognized by the Sharia? No, it was not. It was not recognized by the Sharia. We know this for sure. Then this maslaha, no one can basically come back and say, stop the cultivation of grapes to avoid, this is called Pharisaic tendency. Pharisaic tendency is when you use the Sharia and you have secondary and tertiary prohibitions to prevent the violation of the Sharia. The Pharisees are, some of you know, some of you don't, but Jesus condemned the Pharisees. These were, part of the scholarly community in the Jewish community. And what they would do out of scrupulosity, misplaced scrupulosity, and maybe pretentious, maybe stuff, they would erect sort of fences around the Sharia. And Islam came to, Islam wanted to stop that. Islam wanted to stop that because that tendency will always be there. people who consider themselves to be more religious, stricter, they will want to add to the prohibitions to protect the original ones by secondary and tertiary prohibitions. So then he said, so some interests are recognized, some interests are rejected, and then he said that some interests are neither affirmed nor denied. The Sharia neither affirmed its consideration nor denied its consideration. These are the masalih al-mursala, which according to Imam Malik are considered a valid legal proof. That is Imam al-Qarafi speaking about Imam Malik, the great Malik, he's speaking about Imam Malik. So you take this, and then, so that's the whole issue. The issue here, when they call the mursala unrestricted, they meant that they are not recognized and they are not denied by the Sharia. Not recognized, not denied. They're just out there, masalih. It's not true. I beg to differ. They are recognized because the attributes and whatever I have here for you, this actually is not, this is certainly present, like, I'm not going to invent anything new, but the way I brought them together took a lot of effort. And I want you to just get this down and get it right. So attributes that are consequential. Acts have attributes. Those attributes can be consequential to legal rulings or not consequential to legal rulings. Al-awsaf, attributes of different acts, they come in basically 5 different levels with regard to their consequentiality, with regard to their effect on legal rulings. The first one of the 5 is al-wasf al-mu'athir. Al-wasf al-mu'athir would be basically an effective attribute. In fact, we call al-illa what? Effective cause. This is an effective attribute. Effective attribute, basically, the Sharia testified to its specific effect in the specific ruling. The Sharia testified to the specific effect of intoxication in the ruling of prohibition. Specific effect, specific ruling. Prohibition of drinking, intoxicants. So is specific and specific, specific and specific, okay? That is called al-wasf al-mu'athir. Minority and guardianship. Guardianship is not one type. There is guardianship over marriage, there is guardianship over wealth, but minorities effect in guardianship over wealth. That is specific and specific, right? Specific and specific. Let's move to the next one. Al-wasf al-mula'im, which is well-suited. Mula'im means what? It is well-suited to base the ruling on it. Here, the Sharia had testified to the specific effect in a general category or the general type in a specific ruling, such as what? So, okay, minority is something specific or not? Specific, minority, to basically not be an adult yet, minority, specific. If we talk about minority within the context of guardianship over wealth, that's specific and specific. If we talk about the effect of minority in guardianship as a category, and then you start to basically make parallels between guardianship over wealth and guardianship over marriage. That is called specific in a general category, not in a specific category, not in a specific ruling, in a general category of rulings. The other examples that basically says does the opposite is what? in minority and guardianship in general, what was specific and what was general. What was general is category of rulings. What was specific is the attribute itself and its effect. If you take, as in the Hanbali madhab, hardship and combining the prayers. Hardship and combining the prayers. Combining the prayers is a general category of rulings or a specific ruling? Specific. What about hardship? Is it a specific attribute or a general category? General category. So that is general and specific. The first one, minority and guardianship, specific and general. Now general and specific. Okay? These are well-suited attributes. Well-suited attributes. وصف ملائم. And then you have the unrestricted attribute. Unrestricted attribute is what? Not a specific and general, not general and specific, it's actually general and general. General and general. Such as what? The basically effect of the general category of preservation of life and wealth in the general category of rulings related to roads, related to traffic, for instance. Does that general category have effect on that general category? Yes, we have known from the Sharia that general category is consequential to that general category of rulings. That is al-maslaha al-mursala. That is how you say that you have to follow traffic lights and even the sort of the lines and paving and stuff like this. That is how you get to this. Is this unrecognized by the Sharia? No, it is recognized by the Sharia, but it's a different type of recognition. It may not be as strong as qiyas, that's specific and specific, intoxication, and prohibition of drinking or consumption, but it is still recognized by the Sharia. After al-wasf, this is called the munasib al-mursal, which is general and general. Then you have al-mursal al-gharib. It's unrestricted and unrecognized. Unrestricted and unrecognized. So that is what Imam al-Qarafi, that would have been what Imam al-Qarafi meant, but I believe that Imam al-Qarafi meant by saying it is neither validated or affirmed the third category, not this category, because this one would be inconsequential. Like they say, for instance, that if two partners have a slave, shared slave, and they get into a contract, manumission contract or emancipation contract with that slave, the partner that basically voids the contract, they say that we've never seen that the Sharia paid attention to harm that may befall that partner. The Sharia pays attention to the harm that may befall the slave and the other partner that did not basically void the contract. We've never seen that the Sharia had paid attention to the harm or paid attention to the interest of the person who voids the contract of emancipation. Then the last one is al-gharib. Al-gharib attribute is where the Sharia explicitly invalidated it. Explicitly invalidated it. So Imam Abu Abbas ibn Taymiyyah rahimahullah said that when it comes to masalih, people go to extremes. So some people will just go by masalih for everything, and some people will not recognize masalih that the Sharia does recognize. And then he will talk about, the proofs of both parties, those who affirm and those who negate, and those who go to that extreme, those who go to the other extreme. And then he speaks about the fact that this resembles the discussion on istihsan, rational determination of goodness, discussion on ra'i, personal reasoning in the Hanafi madhab, discussion, all of this. And then he says the synthesis, which is al-Qawl al-Jama', is the Sharia neglects no true interest whatsoever. Allah perfected the religion, the Prophet ﷺ left us on al-Mahajj al-Bayda, the radiant clarity, and so on and so forth, he says. As for what the intellect may perceive as an interest, yet the Sharia has not spoken on it, one of two things must be true, he says. One of two things must be true. Either that the Shara dalla alayhi min haythu lam ya'lam hadha an-nadhir, either that the Sharia did actually point to it by an indication that is too subtle for that examiner to observe. By an indication that is too subtle for that examiner to observe. Or it is not an interest. But the Sharia never, left no good whatsoever except that it pointed us to it. No good whatsoever except that it pointed us to it. No harm or evil whatsoever except that it warned us of it or against it. So the bottom line for him is that, the Sharia must have borne witness to that maslaha. And what he said is basically exactly what we uphold. We think that al-masalih al-mursala, including the masalih al-mursala that Imam Malik, rahimahullah wa radiya anhu, upheld, were these that are recognized by the Sharia, not unrecognized, but recognized in a way that is more subtle than, let's say, qiyas and things of that nature. So among the examples of how needs are recognized in our Hanbali madhab, if you go to Ibn Rajab's 130th, Imam Ibn Rajab rahimahullah, in his 130th qaida, he said that dwelling, the servant, al-markab, means of transportation, one needs, are not considered surplus. Not considered surplus in the sense that you don't have to pay, you're eligible for zakat even if you have all three. So you have a house, and you have a servant, and you have a horse. Are you eligible for zakat? Yes, you are, according to Imam Ahmad, if you still have needs that are unmet. If the house is more than your need, are you still eligible for your zakat? Yes, Imam Ahmad says, yes, you are, unless it is way beyond your needs. Way beyond your needs. Look at this. It's basically humanity. Like, if someone has a house, and they became needy, the house is a little bit bigger than their needs. Will we push them out of their home that they lived in for 20 years just because, they're now broke, or they now have needs before we come to assist them? He says no, unless the house is way beyond your needs, and in this case you need to downsize. In this case you need to downsize, but you will be eligible for zakat, and we will not ask you. So sometimes he was asked about a servant who has a particular person who has a servant that is worth 100 dinars, very expensive. Well, I'm used to that servant, in these times. There is a need, they know my needs. Do I have to give up the servant, or do I have to give up the house? He says, no, you don't have to give up the house, the servant. And he says a horse that you use fi sabilillah, you don't have to give that up as well. You still can get zakat. You're not going to be asked to sell any of this to go to Hajj. You're not going to be asked to sell your daya, your farmland, or part of your farmland to go to Hajj. You're not going to be asked to sell your rental properties. If you need those rental properties, not your home, your rental properties, if you need them or your dependents need them, you're not going to be asked to sell any of that to go to Hajj. A bankrupt person, we will not take their home away from them. We will not take the home away from them. And we will not take those needs away from them. Extra, yes. Fudul, excess, yes. But not those needs. Supporting your relatives. You have he was asked specifically about someone who's been asked to sell his house to support his father. He said he needs a house. And then they also spoke to him about rental properties to sustain relatives or maintain relatives. And he said if he needs them, then he doesn't need to sell them. You know, if he has excess, if he has extra, then he would be responsible for supporting his relatives. And then he said at the end that these rules should likewise apply to what? You know, that we're not going to strip you of your house, your servant, your means of transportation, even if you become bankrupt. We're not going to ask you to sustain your relatives if you don't have surplus over these needs. We're not going to ask you to sell anything to go to Hajj. We're not going to even consider you ineligible for zakat if you have these things, and a little bit more, like the larger house, for instance. Then he said that these apply as well to jizya, kharaj, and the aqila obligations. Aqila obligations, blood money that we collect from the aqila. When we collect the blood money from the aqila, the paternal kin, we will not ask them to sell stuff, you know, they need to pay the blood money. Kharaj and jizya, this is Ahl al-Kitab now. These are not Muslim. We will not ask them basically to sell the things they need, to pay the jizya, to pay the kharaj. The same sort of kindness should be extended to them as well. So, other applications where need is considered, the permissibility of entering bathhouses, for instance. You know, bathhouses, when you went to a bathhouse, it pretty much like open buffet. You know, how much water and soap would you use in the bathhouse? How long would you spend in the bathhouse? When you enter the bathhouse, it was like one standard fee. And then you come in, and then the amount of water and soap and this and that you use is basically, but this is how it was done. Therefore, they allowed it. Is there gharar here, ambiguity here? Yes, because we don't know. Someone may use like so much water and so much soap and so much this and that, and nowadays electricity in the sauna or this, and someone may use very little, and we're just taking a standard fee from all of them, one fee from all of them. Is this permissible? It's permissible. Why? Because it's needed. This transaction, we need to do it this way. There are many things that we take for granted as permissible, although they may have some like issues, you know, although it's very contestable, and you can certainly read Imam Ibn al-Qayyim's discussion of whether these issues are contrary to qiyas or not. Very contestable, but many scholars said all of these issues are contrary to qiyas. Lease. What is the problem with lease? Rent. The problem is that you're selling a usufruct that's not existent yet. You're selling a usufruct, a manfa'a, the use of the property is non-existent yet, and you are selling a usufruct that is non-existent yet. Ja'ala, contingent reward contracts. Contingent reward contracts. We've gone over the difference between ijara and ja'ala. Ja'ala is whoever finds my camel gets $100. Okay? How much time? How much effort? Undetermined. You know, undetermined. Time and work, undetermined. Is this ambiguity? Ambiguity, of course, but it was forgiven. So, hawala. Hawala is what? You know, you're indebted to someone is indebted to you, you get out of it, and you tell X to get his money from Y. That is debt transfer. That should be by default forbidden, but it was allowed for the need and the ease it brings. Salam contracts. Salam contracts, should they be problematic or not? Yes, a non-existent property. you are selling a non-existent property. What is salam contract? Salam contracts is when I give you $100 to give me 100, basically kilograms of a certain type of wheat next year, on such and such a date. Is this a problem? Yes, because the property is non-existent, and we know that bay' al-ma'dum is forbidden. Sales of non-existent items is forbidden. It was allowed because of the need. The permission for khiyarat, the many khiyarat or options in sales, shouldn't the finality of sales be the default? Yes, but we've allowed many khiyarat because of the need. These rulings are firmly established in every age because of the needs. And then there are dispensations that are established in the text, such as al-araya that we've talked about before, plating vessels with silver, looking at a prospective spouse. Was it allowed for a need? Yes, it was allowed for a need. How much was allowed for a need? They disagree and they differ, and we've gone over this before. Establishment of bureaucratic agencies, which is dawaween, minting of the dirhams and dinars. All of this has been based on masalih. That is why Imam Ibn Aqil says something that is quite profound when it comes to siyasa. He says, if by your statement, la siyasa illa mawafaq al-shara, there is no policy except that which accords with the Sharia, you mean that it does not contradict what has been explicitly stated in the Sharia, ma nataqa bihi, then that's correct. But if you mean that it must be explicitly stated in the Sharia, then that is mistaken, and it entails attributing error to the companions. وغلط وتغليط للصحابة, attributing errors to the companions. Ibn Taymiyyah rahimahullah says, he has numerous applications, particularly in commercial jurisprudence. That is why you'll find someone like Dr. Ali Jamal, who's the a former mufti of Egypt, despite all the contentions he has with Imam Ibn Taymiyyah, which are unfair to a great extent. Just unfair. But he oversaw the writing of a 3-volume book on, the Nazariyat Ibn Taymiyyah fil Aqd, or Ibn Taymiyyah's theory regarding contracts, and al-Uqud al-Maliyya in general, his contribution to discussions over al-Uqud al-Maliyya in general. So it was, certainly he has like so many valuable gems in his theory about contracts. But one of them, for instance, is when he speaks about, gourds and melons and, fruits that come out one batch at a time, but they keep on coming out like at different times. You have the roots and like, cucumber, for instance, and watermelons and gourds and things of that nature. So if I have to sell one batch at a time, and if I have to sell what has already ripened, they keep on ripening like all the time. So if I have to basically come today and sell everything that has ripened, just that, and then come in 2 other days and sell everything that has ripened, just that, and then 2 other days, everything that has that, he says that entails usr, that entails difficulty, ta'adhur, sometimes close to impossibility. Therefore, because of that need, and he says, forget about, the justification that some of the scholars, keep in mind that Hanafis, Shafi'is, and Hanbalis in their mu'tamad, all of them say, yes, you have to sell it, batch by batch, about 1 batch at a time. So whatever has ripened. So only the Malikis and some of the Shafi'is that said, no, you could sell it basically like until the roots dry up. until the roots dry up, until there is no more harvesting of the watermelons or cucumbers or gourds or this or that. But you could sell the whole, patch of land that has these fruits. You could sell all the fruits, and then they harvest them at their convenience. And he says two justifications for this. One justification is to make a parallel between selling the fruits with the roots and fruits with the trees. And so some of the scholars who wanted to justify this, who wanted to explain the selling of the fruits with the roots, they said this is like selling fruits with the trees. So if it is allowed to sell fruits with the trees because of a qaida that we will address after we finish the 5 major legal maxims, one of the two biggest ones that we will address, الإعمال أولى من الإهمال, and التابع تابع. التابع تابع is, it means what? It means the secondary is secondary. Secondary is secondary, meaning that if selling fruits before they ripen is haram. But if I'm selling the trees, I'm going to sell the fruits with them because it's taba, it's secondary, it's not the primary contract, okay? So they said, I will make a parallel, but this is certainly a problematic parallel because the roots are not trees. The roots of these fruits are not like the trees here. And he says that justification for this is the need, haja. These types of fruits were not included in the Prophet's prohibition of selling fruits that have not ripened yet. They were not included, and people in all cultures, in all societies, have been selling them like this. Therefore, there is a need and there is difficulty in doing it otherwise. That is just like, the hammam, for instance, the bathhouse. We've said that there is a need. I mean, we just can't, we can't hire someone to monitor how much water and soap you're using. So everybody is going to pay the same fee, but what you're getting may be completely different. And that is how many of the scholars are saying open buffet is still okay. Okay, then, so are hajat considered? The bottom line, we want to say hajat are considered in the Sharia. Did the Sharia testify on behalf of these hajat and their consequentiality on legal rulings? Yes, but it's a different testimony. Unlike qiyas, it's not specific and specific, and it's not even specific in general specific, it's general in general. So, but the scholars have stipulated several key conditions for a need to permit what is otherwise prohibited. And Sheikh Abdurrahman al-Abdul Latif, in his book al-Qawaaid al-Fiqhiyya al-Mutadammina lil-Taysir, mentions 5 of them, and I will add another one. He says the hardship motivating the departure from the original ruling must reach the level of extraordinary difficulty. Remember, we've talked about al-mashaqqa al-mu'tada fi al-taklif, ordinary difficulty. Anyone who wakes up for Salat al-Fajr will find some difficulty. We call this mashaqqa mu'tada fi al-taklif. And that is how Imam al-Izz ibn Abdul Salam says, this is how you gauge things. Look at this type of worship. Look at dispensations that would made in this type of worship. Look at the ordinary mashaqqa in this type of worship and the dispensations. This will give you an indication of the mashaqqa that would be tolerated in this type of worship and the mashaqqa that would not be tolerated in this type of worship. The second condition is standard for assessing such a need has to be based on the condition of the average individual. If we're talking about public needs, then it has to be based on the average individual. If we're talking about a private need, is it based on the average individual in public? No, it's not. Because that poor man who has a large house, you are not going to say, some, like the zakat committees, like sometimes they have these questions. Someone comes in and asks for zakat, and they have an expensive watch, they have an expensive car. Maybe it is, yes, if it were my child, I would tell him never go and seek zakat before you sell your car and replace it with another one. But does that mean that you don't give them zakat because they happen to have like a nice car? Maybe it's a car that they had for 6 or 7 years and they have a difficulty now, and the demand that they sell this car, maybe it will be harder for them to replace it. Maybe this, maybe that. Just apply the same concept of the spacious home to some of these things. So you're going to consider the socioeconomic status of the group, not the public. The group that this person belongs to. The group that this person belongs to. If he comes from a socioeconomic status where these things are not unexpected, then they may be deserving. Shafi'i said that a jeweler, you can give zakat to a jeweler to basically get them back into business, get them back into their jewelry business. So the need needs to be definitive and unavoidable. So no other viable means of achieving intended purpose except through breaching the prohibition, preaching that which is prohibited. The need must be proportionate and judged according to its extent. If we say الضرورات تقدر بقدرها, necessities are judged by their extent, we must also say needs are judged by their extent. The ruling based on the need does not contradict an explicit text from the Quran and Sunnah specific to the issue, nor oppose a stronger legal analogy, stronger qiyas. And it must be also aligned with the maqasid of Sharia, and it should not result in the loss of a greater interest. One may further add that the prohibited matter is often of, this is my addition now, that the prohibited matter, all of this we're looking at the need, but we have to look at the prohibited matter, and it is often of muharramat al-wasa'il, whether it's muharramat wasa'il, muharramat as a preventative means, not inherently evil, or muharramat because of their acquisition, or this or that, not intrinsically, inherently evil muharramat. Then, the question that must be asked is general need the same as specific need in this regard? General need and specific need. So remember Imam Suyuti and Imam Ibn al-Jaym said that al-Haj amma kanat aw khassa, al-Haj tanzil manzilat al-darura ammatan kanat aw khassa. So needs assume the rulings of darurat, whether they are general or private. Remember we said that this is too ambiguous and needs. So we believe that needs in general are consequential, whether they're private or public. But needs in general are not like darurat. The private needs do bring about facilitation, but not like darurat. Not like darurat. As for public needs, do they bring out facilitations like darurat? Yes. Yes. Public needs, yes. And the point is very straightforward, very straightforward. For a whole community to endure the hardship that ensues from neglecting public needs, there is a lot more harm than one person enduring the hardship that ensues from neglecting a private necessity. So the two examples that would make things clearer in the discussion of al-hajat and al-darurat, and al-haj al-amma tanzil manzilat al-darura al-khassa, which is basically a public need will assume the same rulings of the private necessity, which is our preferred basically formulation of the qaida versus the formulation of Imam Abu Suyuti and Ibn al-Jaym, which said al-haja tanzil manzilat al-darura amma kanat aw khassa, that a need will assume the ruling of darura whether it is public or private. And of course, the two great imams did not mean anything wrong, but the ambiguity in the formulation is what we try to basically address, and we said that the earlier Hanbali Imams never used that formulation, and later Hanbali Imams have contested the ambiguity in the formulation. Of course, Imam Suyuti and Ibn Nujaym does not mean that every haja will be treated like every darura. But two examples to make this clear would be what? Would be comprehensive insurance and student loans. Comprehensive insurance and student loans. You know that AMJA, the Assembly of Muslim Jurists of America, has allowed comprehensive insurance for the basically various needs that people would want this for. And you know that AMJA has allowed student loans as well for the public need. What is the difference between the two masail or the two issues? Exactly. And why did I say comprehensive insurance and not insurance? Because liability is forced on you. You can't drive a car without liability. Okay, the issue is comprehensive insurance and student loans. Student loans have been allowed by AMJA for what? Public need. Would they have been allowed for a private need if it were not a public need? Let's say student loans were not a public need. Would we allow them for a private need? No. Why no? Why not? Because of different things. One, you don't really, like it's not such a pressing need for every individual, and many people may do better without a degree to start with. And there is like a lot of discussion on this issue, like whether a degree is worthwhile or not. We believe it's worthwhile, but not for every individual. And for particular people, they may do much better without a degree. But that's one thing. The more important thing is, what are we permitting here? Riba, usury. Student loan is basically a usurious contract. Now, this is based on the understanding of the vast majority of contemporary Muslim scholars that riba applies to cash, to dollars and pounds and so on and so forth. There are Muslim scholars, and you just can't deny them their scholarhood or their scholarship. They are scholars. They are Muslim scholars who said that riba does not apply in cash to begin with. Riba applies in gold and silver, does not apply in cash to begin with. The vast majority of Muslim scholars and basically the agreement of the assemblies and fatwa bodies and councils and so on and so forth is that riba does apply to cash. Riba applies to cash. And there is riba in cash, just like there is riba in gold and silver, because the illah of prohibiting riba in gold and silver is a thamaniyya, that they are prices for commodities and so on. But this is another discussion that we will not get into. We're assuming that we are upholding the position of the vast majority. Riba applies to cash. What you're doing in student loans is riba. You're getting $100,000 from the financier to pay for your college tuition, and then you will return $200,000 to the financier. That's the definition of riba in this case, because the financier is exchanging money for money without any liability. Okay. So in this case, we allowed it for a public need because the hurma of riba would not be violated for a private need, particularly if that need is not that pressing. because you could do okay without a degree. Comprehensive insurance, what are we violating when it comes to comprehensive insurance? Gharar. Undue risk-taking, ambiguity in contracts with undue risk-taking. Because when in insurance, like you could pay like $200 every year for 50 years and never get into an accident. And you could basically pay $200, and in the first year, you could get into an accident and get like $3 million, from an insurance company. So that level of ambiguity and undue risk-taking is the basis of many, many prohibitions in Islam. But is the prohibition of gharar, because it's intrinsically evil, tahrim maqasid, in and of itself is evil, or is it because of what it leads to? It leads to shahna and baghda and, conflict and disputation and so on. Because of what it leads to, not because it is inherently evil or intrinsically evil. This type of tahrim is a degree lower than this type of tahrim. Therefore, comprehensive insurance, we've allowed it. Period? No. For a private need. Like personal need. If you cannot afford, like if you have a $30,000 car and you cannot afford the total loss of your car, then get comprehensive. Your car will be stolen. You will suffer difficulty, some degree of difficulty or hardship. If you're Elon Musk, should you insure your Tesla? Probably not. If you're Elon Musk and you're driving a Tesla, should you use this to justify having a comprehensive insurance on your Tesla? Probably not, or any other car, But so you still need to have a need. The need still needs to be legitimate. If you're a multimillionaire and you have a $30,000 car, you can replace it if you lose it. You can easily replace it if you lose it, whether you lose it in an accident, whatever, but you could easily replace it. Do you have a need? No, you don't. It doesn't apply to you. But as a private individual, as a person, if that is not the case, and the loss will cause you distress or hardship, then you're allowed to get comprehensive insurance, because the violation here is a violation of gharar. It's less than the violation of riba. But here we've allowed it for public need. And that is where the jurist has to have an understanding of the reality. They call this fiqh al-waqa, etc. But it is essential, because your rulings will operate within that reality. So you have to understand the consequences of your rulings. So if you prevent generations of Muslims from higher education, some of you read my last post about the revival of the Muslim sort of revival, the material revival in particular of the Muslim Ummah, and that it will come at the hands of faithful realists. And if you don't understand the importance of science, if you don't understand the importance of education for the collective, you don't understand the difference between the collective and the individual, you will have to understand it. There is a huge difference between the collective, يصابرون فقد الحاجات, and an individual, يصابر فقد الحاجات. An individual enduring the difficulty that ensues from the unmet needs is completely different from a community. A community cannot endure the difficulty that results from unmet needs. Therefore, if we deprive generations of Muslims from higher education, what are we doing to the community at large? That in general, it could be a lot more harmful than one person enduring the loss of, an essential need. That one person enduring the loss of an essential need. So these will basically give you like some understanding of the difference between different types of محرمات, غرر and riba, تحريم وسائل, تحريم مقاصد, تحريم because as a preventative means to like some evil, تحريم because of being intrinsically evil, and the difference between a private need and a public need. Both of them are needs, and we have to respect the need, and the need has to be judged according to its extent, like the darura is judged according to its extent, and all of the regulatory maxims apply, but there is a difference between a private need and a public need, and hopefully Imam al-Juwayni's discussion gives you like a taste of this. There is a difference between, the collective enduring hardship and difficulty and an individual enduring hardship and difficulty, because the collective will falls together. If you don't have if you don't, craftsmen, like you just can't ask everybody to basically wait to reach the level of necessity, because when you have a widespread unmet need, that will have a huge impact. And we will see how Imam al-Haramain al-Juwayni rahimahullah and al-Ghiyathi spoke about this point in particular. So the correct position is that al-Haj al-Amma may in fact take the ruling of a specific necessity, because في مصابرة الجماعة للحاجات مثل ما في مصابرة الأفراد للضرورات من الفساد وأشد. The corruption that results from an entire community enduring hardship may be equal to or even worse than that which befalls individuals in enduring necessity. Imam al-Haramain rahimahullah said, لو فسدت المكاسب كلها وطبق طبق الأرض الحرام في المطاعم والملابس وما تحويه الأيدي وليس حكم زماننا ببعيد من هذا. If livelihoods become wholly corrupted and the land is filled entirely with unlawful gain in food, clothing, and possessions, and our own era, look at this. He's speaking about his own era. He is from the which century? 5th century. He's speaking about his own era. And our own era is not far from such a state. What about us? Then he says, can we tell people to abstain until they reach the level of necessity? Can we tell all people to abstain until they reach the level of necessity? He said, if the situation we described were to occur, there would be no way to compel people under such conditions to abstain from their daily sustenance and strip themselves of what clothing they can afford. For if people were to wait in what they eat until reaching a state of necessity before consuming food, that would result in physical collapse, loss of resilience, and the breakdown of bodily function, especially if such desperation were to become habitual. This would lead to craftsmen abandoning their trades and professions, to the collapse of farming, cultivation, and all means of earning a living by which the human society is sustained. He's talking now about a community that is backwards and weak. What happens to this community? The end result would be the destruction of the entire population, including the capable and strong, as well as the soldiers guarding the frontiers of the Muslim lands. And when they falter, weaken, and give up, the disbelievers would become emboldened, infiltrating Muslim territories, tearing apart the fabric, and dismantling the order of society. The general principle to be drawn from this before we enter into its details is that فالقول المجمل في ذلك إلى أن نفصله أن الحرام إذا طبق الزمان وأهله ولم يجدوا إلى طلب الحلال سبيلا فلهم أن يأخذوا منه قدر الحاجة ولا تشترط الضرورة. If unlawful means overtake the people of a time such that they have no way to seek out the lawful, they may take from the unlawful that which meets their needs. The level of necessity that we typically require for the consumption of carrion by an individual is not required here. So could you sympathize with, some of the muftis in the former USSR states that allowed Muslims to eat non-slaughtered meat because basically they can't slaughter, Would that be something to consider? Rather, the need of the collective assumes the status of necessity for the individual. For if a single person in a state of necessity were to endure without eating carrion, he would perish. Likewise, if the general public were to endure their unmet needs until they reach the level of necessity, all of them would eventually perish. The threat posed by widespread unmet need to the entire community is like that posed by necessity to an individual. So understand this and you will be guided. تفهموا ترشدوا. تفهموا ترشدوا. Now, are there exceptions to this, this entire discussion that we had? And I hope that it has been made clear to you, because I really like one thing I hope will make up for my countless shortcomings and failures is that when I teach, I truly, like every cell in my body, wants you to understand the subject better than me and wants you to just get it down right and to benefit you in your lives, to give you stability, to give you strength, to give you joy also, to love the deen and to experience that sweetness and the joy of faith. So, hope you understood this. Are there exceptions? Of course, there are exceptions. There are regulatory criteria, ضوابط, that we have talked about before, and not every need permits what is otherwise prohibited. And I'll give you one example. Bay' al-Wafa, for instance, was considered a need by the Hanafi scholars at a certain time. Hanafi scholars in parts of Asia, a lot of people became indebted in the society. A lot of people were basically suffering from debt. So some of the Hanafi scholars allowed Bay' al-Wafa, and Bay' al-Wafa basically is, or Bay' al-Amana, is when you sell an item with a promise to take it back, at the same price after a period of time. So why did people want to do this? They wanted the cash. So now I'm going to sell my house, and you promise me to sell it back to me next year. What's the problem here? At the end of the day, this is a qard, this is a loan that entailed some benefit. What is the benefit? Because when you purchase my house, you'll be the owner. Will you have the right to use it or not? Yes. So it's qard jarra nafa. It is a loan that basically brought some benefit to the creditor. So in this scenario, should we allow this because of the need? The vast majority of scholars, these are just some Hanafi scholars, not all Hanafi scholars, some Hanafi scholars allowed Bay' al-Wafa. Vast majority of scholars have not allowed this. They considered this to be like a loophole, like what? Like Ashab al-Sabt. So they didn't allow this. So will this concept can this concept take us to, violating the Sharia or cause us to violate the Sharia like Ashab al-Sabt? Yes, if it is not well regulated. So exceptions from the general مشقة تجلب التيسير, and you will find me when it comes to the exceptions, you will find me not talking, not basically mentioning many of the applications, because we've gone through the exceptions already. Throughout our discussions, we've covered many exceptions, and more importantly, because the qaida should be muttarida, should be consistent. The qaida is consistent. The qaida is muttarida. And whenever you have an exception, the exception must be justified by what? By another qaida or a text of revelation. There is no exception from a consistent qaida that is not justified by another qaida or a text of revelation. So hardship is undoubtedly lifted. مشقة تجلب التيسير is a consistent قاعدة. Hardship in Islam is lifted. ما جعل عليكم في الدين من حرج. Hardship is lifted in Islamic law, yet not every difficulty warrants a concession. Even the qaida necessities permit prohibitions is governed by several criteria. Likewise, concessions are not granted in the case of sin. This qaida, الرخص لا تناط بالمعاصي, excludes many applications. We have also encountered several cases over which the scholars differed, such as the issue of not delaying the implementation of Had, until recovery of a sick person. And we've said that the later Hanafis said that it should not be delayed. Earlier Hanafis said it should be delayed. This is a matter of controversy between earlier and later Hanafis. Not excusing one who engages in intercourse forgetfully, whether it is in Hajj or it is in the fasting of Ramadan. And we said that some scholars, including Imam Taqiyuddin, excuse them. And the validation of a marriage contract conducted under coercion. And we've said that this is the mu'tamad in the Hanbali madhab. We will still validate it even if it is conducted under coercion. But we said this is a matter of disagreement as well. And you'll find, scholars like Imam Taqiyuddin would say it is not valid because it is done under coercion. So anyway, that shows you what the Qawaaid are consistent. The Qawaaid are meant to be consistent, and the more consistent you are in applying the Qawaaid, and the more deliberation you exercise in adhering to the Qaida, and not jumping to exclusions and exceptions and so on and so forth haphazardly, the greater faqih you become. The more the more insight you will have in the religion and in the Sharia. You have to have Qawaaid. These are guardrails. These are tracks that you should be observant of all the time in your exercise of fatwa and in your understanding of the Sharia in general. You have this capacity of abstracting kulliyat min al-juz'iyat, abstracting universals from particulars, is extremely important and maybe the most sort of consequential to people's understanding of the world, is their capacity to abstract kulliyat from juz'iyat, universals from particulars. أقول قولي هذا وأستغفر الله لي ولكم سبحانك اللهم وبحمدك أشهد أن لا إله إلا أنت أستغفرك وأتوب إليك. And العادة محكمة will be next, but next is not next week. Unfortunately, I will not be able to make it next week, so next will be in 2 weeks, inshallah. We will go over al-'ada muhakkama. Customs are authoritative. أقول قولي هذا وأستغفر الله لي ولكم. Let's come back at 9:35.